Good morning. We are here for the December 5th meeting of the Environmental Control Board. Hope you're all doing well and had a nice Thanksgiving holiday. I'd like to call today's meeting to order and ask the parliamentarian to do a roll call to verify quorum.
Good morning, everyone. Commissioner Asim Khan.
Present.
Department of Buildings.
32 present.
Thank you. Joseph Gregory.
Present.
Elizabeth Nauer.
Present.
Madeline Ligori.
Present.
Russell Pecunis.
Present.
Harminder Kaur Rana.
Present.
Matthew Schneed.
Present.
Thomas Spatner.
Present.
Matthew Smith.
Present.
Douglas Swan.
Present.
Lisa Urban.
Present.
Jared Whittington.
Present.
Did you say Schneid?
Schneid, yeah.
Okay, from now on.
No problem.
We have a quorum 13 out of 13.
Great, thank you very much. We have a written attendance list going around, so please sign that if you haven't. Get Russ to sign and then send it down for Lisa. All right, our first item on the agenda are the minutes of the October 10th, 2024 meeting. Does anyone have any corrections to the minutes? Okay, may I have a motion to adopt the minutes of October 10th? A motion and a second. We see a second.
Are there any objections to the motion adopting the minutes of the October 10th, 2024 ECB meeting? Seeing none, hearing none, the motion is approved unanimously.
Thank you very much. Okay, we'll next turn it over to Russ Pecunis from DEP regarding a cease and desist order request.
Yes, thank you. Good morning. For this meeting, DEP has a request for the board to issue a cease and desist order for 2351 Richmond Terrace in Staten Island. This is a rather remote location under the Goethals Bridge, which is a cement facility. We had one of these a few months ago in the Bronx, which was a similar situation where they did not have a valid certificate of operation for the cement silo, and the cement dust was affecting the surrounding neighborhood. Despite its relatively remote location, we have gotten a lot of complaints about this facility. The one in the Bronx, by the way, did not appear for its hearing, but has come into compliance. So we are going to be submitting something probably for the next board meeting to discontinue that cease and desist order, since they are now in compliance. But as far as this one is concerned, they were cited in July for a violation which they stipulate in July of 23 for a violation which they stipulated to in November of 23. They were then cited again at the end of 2023. That summons was, I believe, defaulted and has now been rescheduled for January 13th. And a third summons was issued just around about 3 weeks ago, which also has a hearing date in January. And given the fact that we are continuing to get complaints, they are not in compliance. We are requesting that the board issue a cease and desist order. I did include a photograph with the documentation, and you can see on top of this like rectangular column are the two rectangles. On top of that are the dust collectors that are supposed to be keeping the cement dust from being emitted into the surrounding air. And actually, you can see in the background, I think, of that photo is the bridge, the Goethals Bridge. It's like right next to the Goethals Bridge. So if there are any questions or,
What's the, what would the relationship to the cease and desist order be to the January 27th hearing? They'd have the hearing coming up.
it's just that
How
that
would
one is
play out?
pending. I
Yeah.
mean, we can't really, because these things, as you can see, the first violation was issued well over a year ago. The histories of these things sometimes become very prolonged. And when they are fielding more or less constant complaints about a location, and since the board meets only every 2 months.
Yeah.
We want to bring this in front of the board instead of waiting until the February meeting for the 2 hearings to take place in January.
Okay.
And so one thing I'm a little confused about is they only had one hearing over the past 2 years, right? The first summons, the second summons was like a year ago already.
The second summons went into default and they have apparently recently rescheduled it so that it is now on in January. But it was issued back at the end of 23.
Right, so they must have defaulted a long time ago.
Presumably they defaulted on that one sometime, if it was issued late at the end of 23, presumably they defaulted on it sometime in early 24. I don't have that specific date, but the ticket finder does indicate that it's been rescheduled out of a default.
And then what was the stipulation? They just agreed to cure it?
Hmm?
In 20, the stipulation they had in 23, they agreed to cure the problem at that time?
Whenever you stipulate, part of the stipulation is that you agree to compliance. Whenever you're found in violation, stipulate, or even in the default order, there's always a provision that you have to come into compliance.
Other comments or questions? Yeah, Elizabeth.
I just wanted to note that I need to abstain from this vote. Based on the name, it looked familiar to me, so I did a conflict check last night when I was reviewing the materials, and my firm does represent this entity, and I don't think with respect to these violations, but just putting that in for the record.
Thank you for letting us know. Any other comments or questions? Okay, can we have a motion to approve the request for the cease and desist order? A motion and a second. We see a second. Okay, the request for the cease and desist order relating to respondent FMB Materials, Inc., Island Ready Mix, Inc. is approved. Thank you very much, everyone. Oh, I'm sorry. Let's take a vote.
Are there any objections to the motion approving the cease and desist order? Seeing none, hearing none, the motion is approved.
Okay, thank you very much. Sorry for that. Poor staff. Okay, the next item on our agenda concerns a notice of proposed rule regarding the water penalty schedule. And just if you will indulge me, I'd like to provide some introductory comments on this just to provide context. The first thing I want to acknowledge is that this was sent late. It was sent out as an addition yesterday to today's agenda. I'm sorry it was not available sooner. I'll get to the timing thing in just a second. But first, I want to discuss what this proposed rule is for. A lot of it has to do with rain. As you know, we've been in a dry season in New York City, and the city of New York recently announced a drought warning and has encouraged New Yorkers to take steps and to engage in water-saving measures. And DEP has a central role in that, in protecting our water supply and enforcing water usage and waste. And as part of that role, DEP very recently sought to update the water penalty schedule to meet this serious need. However, the administrative code says that ECB can set the water penalty schedule. And the law is actually not very clear on whether the Department of Environmental Protection's commissioner has their own authority to set the water penalty schedule. So you have in front of you a copy of the ad code. And the ad code, you go to the second page, has this sentence at the end that says the board in its discretion, may, not shall, may, within the limits set forth in the subdivision, establish a schedule of civil penalties indicating the minimum and maximum penalty for each separate offense. I'll note that this is rare today. This is an anomaly now. While it used to be the case in the past that the board had control over the penalty schedules, that changed. In 2016, as some of you know, there was a shift to move the penalty schedule authority, the authority to edit and change the penalty schedules, into the enforcement agencies. And that's the reality that we've been living under since then, with some limited exceptions, including this one. I do not know why this is an exception, but it is one of the few exceptions. And so for the last 8 years, the model that we've been following is that the enforcement agencies have the authority to the rulemaking authority with respect to penalty schedules. And in my view, and in the view of many of oath, this has worked. It's something that is what we believe in, and as a tribunal, we think we shouldn't be the one setting the penalty schedules. Now, in keeping with that framework of having enforcement agencies set the penalty schedule, what would this proposed rule do? The proposed rule would say that the board delegates to the DEP commissioner the authority to set the water penalty schedule. We have looked into this and determined that it is legal and it is defensible. And if we take a look at the actual proposed rule that you have, from the middle of the first page where it says water penalty schedule in bold, and then throughout the rest, that's the current rule. So the current rule as it exists has the water penalty schedule. And then the pages that follow, except for the very last line of the last page, is the water penalty schedule. What the proposed rule would do is it would delete that and replace it with the underlined text that you see at the top of the first page. And the underlined text accomplishes what I just outlined, that the board delegates to the commissioner of DEP the authority to establish the water penalty schedule. So it's a delegation of authority. If today's proposed rule passes, then we would start the formal rulemaking process, notice and comment, etc. If it passes, then concurrently DEP would do its own rulemaking, such that if the proposed rule passes and if the rule is then implemented after going through notice and comment and the CAPA process, then as soon as it is implemented that day, DEP would have a water penalty schedule ready to go. And there's some urgency here, as we've all seen, given the weather patterns and the city's declaration of a drought warning. This is something that city agencies want to move on as quickly as possible. That is partly why we get to timing. The drought was announced, the drought warning was announced only recently. Then there had to be some planning around this. How can we address this? The idea of delegation emerged, then that had to go through a legal review. And once it was determined that delegation is something that can be done and is defensible, then this text had to be drafted. And as soon as it became available midday yesterday, I asked that it be shared with all of you. I want to be very clear about why you're receiving it the day before. If we could have sent it out earlier, we would have. And I'm sorry that folks did have not have more time on it. So because it was sent out last minute, we could do one of two things. We can discuss it today and vote on it. Or if any of you are not ready, you haven't had a chance to read it, if the overview I just gave you was not thorough enough, and even just taking 5 minutes of time to just let everyone time to read it, if you need more time to think through this, then what we could do is I can hear a motion to adjourn this for a special meeting. And we could schedule a special meeting next week or at the beginning of the following week, not until our next meeting, where we can then adjourn the discussion until that time. That's really just to make sure people have the appropriate time to review this. I don't want to assume everyone's ready. I want to make sure that you've had a fair opportunity to read and understand that. So before we get into the substance of this, let me start with that. Let me start to see, based on everything I've outlined and those of you who have read or not had an opportunity to read it, if there's anyone who feels like, wait a second, I need more time for this. Okay, on that note, then let's discuss the actual notice of proposed rule. Russ,
Yeah, let me
yeah,
just provide a
can
little
we
bit
do that?
more
Yeah.
context
Yeah.
to this in the sense of why are we doing this now? Yes, because of the drought warning, but also because 2 years ago, the drought regulations were extensively revised. For one thing, they were changed from drought regulations to water shortage regulations so that they will apply not only in the case of a drought, but in the case of some other interruption of water service to the city, like one of the water tunnels, it goes out of service for some reason unexpectedly or something like that. So they're no longer called the drought regulations, they're called the water shortage regulations. At the same time, unfortunately, for reasons unknown to me, because I did not work on those regulations, they renumbered a lot of the sections in those regulations. So that the section numbers in the current penalty schedule are not right anymore. If you look at the drought emergency regs, where it starts on 2111. So right now it's 2111 A, B, C, D, E, F, G, H, I. When they revised the regulations, they changed it to 2111 A1, A2, A3, A4, A5. So these section numbers are no longer correct. So in the event we need to enforce these, if there is a drought emergency, which hopefully there won't be, and it's supposed to rain for 3 straight days next week, and hopefully there won't be a drought emergency. But if we ever have to enforce these, the section numbers in the schedule are now wrong. So we don't need to fix the penalties themselves, but we need to fix the section numbers. And that's why we originally came to oath, thinking that oath would do it as an oath rulemaking.
or board.
Or, well, board rulemaking. And then after discussions with oath and the law department, this idea of the board delegating this penalty schedule to DEP was suggested so that every time the schedule has to be amended in the future for whatever reason, we don't have to come and bother the board to do it, because all of the other penalty schedules have been in our rules for 8 years.
Yeah.
So this is the only one that got left behind because of this vague language in the water code that says that the board is to establish may establish the penalties. It was because of that language that this penalty schedule got left behind in oath's rules. So that's just to provide some additional.
Thank you, Russ. Okay, comments? Yes, comments.
I think this is unacceptable. I've been watching the powers of the board whittled down for over a decade, maybe 15 years at this point. We've been moving penalty schedules around like clerks for years with no discernible benefit, other than the waste of everybody's time, in my opinion. A lot of pixels have been spilled over this. I believe the separation of powers between the board and the agencies is an important topic. It's certainly very timely. I expect the city agencies to fall in line because that's what they're instructed to do. But this does nothing to help with a drought. That is pushing on a rope. A drought is a non-issue here. Whether there is one or there isn't one has nothing to do with the sufficiency of these schedules. So let's take that drought argument off the table. As far as bothering the board, I've only been bothered by moving penalty schedules, okay? And we've been doing that for over a decade now, I think. It's no bother if we need to change the penalty schedule. I get an email, I read it. It's about all that happens. Then I come to a meeting and I vote. So there's no bother. So let's take that argument off the table. Renumbering section numbers. Easily done. I'll do it this afternoon if somebody wants to give me access to everything. Okay? It's not hard, seriously. Further, language that's proposed, and I'm referring in pertinent part to the final part of the final sentence, is mush. And partly this is because I've been reading The Power Broker for the last 2 months, but partly because the devil's in the details with these rules. I don't know what rules and regulations promulgated by the board even means here. This is a throwaway sentence that could have profound impact. I don't think anybody's really, I'm not going back to I want to retrade and have more time, but I don't really think anybody really knows what that sentence means. I don't know who the drafter was, but clearly, if the board has the power to promulgate rules, then let's exercise it. And shoving all of these penalty schedules into a agency on the basis of the arguments that have been propounded so far seems to me to be a ruthless winnowing of the board's responsibilities and an abdication of its mandate to effectuate a cleaner and more livable city for all of us. So I want to be on record as being profoundly troubled by our willingness to neuter our own organization. It's been happening for years, and I find it despicable. And I see it as a solution in search of a problem.
Any other comments? Elizabeth?
I just wanted to sort of provide a little historical context in line with what Tom is saying. So some of us have been on the board since the time when we did adopt changes to penalty schedules. I would say that I think Commissioner, the statement you made about, oath as a tribunal, and our view is that we shouldn't be in control of the penalty schedules. I think that is attributing a view that maybe is not, as I think is clear from Tom's statements, is not necessarily shared by the entire board.
I didn't mean to imply that. Thank
Okay.
you for clarifying that.
Okay, just to put
Of
that on
course,
the record.
of
So I
course.
think that when the shift towards the penalty schedules of the board being repealed and agencies adopting their own penalty schedules within their own rules occurred, it was during in a different mayoral administration, a shift that I think was moving towards the eradication of this board, that would obviously require a charter amendment that wasn't put forward. But basically, the sort of impetus was to remove authority from this board, and one of the things being the penalty schedules. I personally do not believe that the board having the power to review and consider penalty schedules proposed by the agencies is inconsistent with the tribunal. I think when the agencies are adopting their own penalty schedules, those schedules are therefore limit the power of the board in terms of the penalties that it can assess against respondents. So basically the board ends up being subject to those penalty schedules adopted by the agencies, even as the tribunal that's adjudicating the sort of, it is unable to adjudicate the fairness of the penalties. So I think that is not, it's consistent with the tribunal to assess penalties that it believes are fair, and having those penalty schedules within the agency's rules deprives the board of that opportunity. So my personal view is it is not inconsistent with the tribunal role to be adopting the penalty schedules. Of course, that's sort of gone by the wayside. I mean, we're past that point here. So I think this is just, a singular outlier in the overall, the shift has happened. it's sort of, this would just be, you know, one individual instance of the board if, you know, I think we know where this is going, but I just wanted to put that historical context on the record from the standpoint of some of us who don't really share the viewpoint that you articulated. That's all.
Comment?
But more of a question, when I wasn't here when it kind of had to shift a couple of years ago, was that by the city council changed the legislation or the board voted to eliminate the powers or limit our powers?
I'll let others comment who are
I'll
here.
be glad to address that. It was the puppet installed by Commissioner de Blasio, Mayor de Blasio. He had a big debt to the TLC and installed this guy who had taxi experience. So that's what happened.
But did the board vote to limit the powers or the city council made a?
No, the city council did nothing of the sort. The board shot itself in its own both feet.
My understanding, I believe, Russ, you were there and you may be able to comment, but my understanding is that the board voted to have the penalty schedule authority transferred over to the agencies. And
Well-
there was a lively discussion and there was,
And it was not
it
unanimous.
was not unanimous.
And it actually happened penalty schedule by penalty schedule because it was subject to CAPA to repeal the penalty schedules that had been adopted by the board in the past. And then for the agencies to promulgate a penalty schedule, I mean, under their own rules. So it happened one at a time over the course of probably a couple of years.
Sounds like what maybe makes more sense is we should be revisiting that change after a decade of seeing it rather than giving up more, right? Because some of these penalties are outrageous on citizens I've seen on many occasions, often unfair.
So, sorry, other comments?
I think they said it all.
Okay. Coming back to my earlier points, first, Elizabeth, thank you for clarifying. When I said our, I did not mean to suggest every member here. That's why we have the board, so that we're bringing other perspectives. I was talking with respect to the agency and my colleagues here at Oak. And I was not here when all of that transpired, and I appreciate that we have colleagues here who do and bring those perspectives. And I went back and had a chance to look at some of the meetings that were conducted then and saw that there was very strong points of view held in opposition to this. But as I mentioned, it's the regime that we've been under for the past 8 years, and I think it's worked. And that, I understand, is not a universally held point of view. And right now, this is an outlier. I understand your point, Matt, of, well, if it's an outlier, maybe we swing everything back in the other direction. I would be very surprised, and just speaking personally, because it's not a policy topic that I've discussed with anyone. But in my experience thus far, I would be surprised if that succeeded. And I also want to note that while I respect the point of view about the change or reduction in authority of the board, in the time that I've been here, I've seen this board very actively address a lot of issues. We've had thorough discussions on issues of public importance. We've had extensive debate over various topics. We've moved resolutions through. We've had to revisit those resolutions after hearing back from the courts. And most importantly, all of you play a critical role in the panel review of the individual decision. So there still remains, in my view, remains isn't even the right word, there is a lot of authority that this board has and a significant role that it plays. Though I understand that delegating this is by definition saying that there is an authority that we have and we are voting to delegate that authority to another agency. Other comments? Yes, Lisa.
So just so I'm clear, this is the only agency at this point that we're aware of that we still have the ability to establish the penalties.
So I don't have the list in front of me, but I saw just yesterday, one other small item. And then I remember last week or this week, someone showing me something that's a type of schedule for a type of conduct that, because of today's age, like day and age, it just wouldn't come up there. It's just a type of issue that is outdated. So I don't believe this is the last one, but it may be, of the last ones, it may be the most significant. If anyone else can comment to
I
that.
think it's the only one that really gets used. I think
Okay.
there are maybe some other ones for things like, the battery disposal penalty schedule or something, or I mean, I think there are a couple of penalty schedules that don't really belong to any specific agency maybe, and that are never really used, that are still in oaths rules, but this happened, and I mean, Madeline, you were here at that time as well. Under de Blasio, they did something called regulatory review. I think it was, where all of the city's regulations, everything in the RCNY was reviewed, and there were a whole pile of recommendations that were then made to make the rules work better, and moving the penalty schedules out of oaths rules into the agency's rules was one of those recommendations. And I believe the rationale is that it would be easier for the public to find them if they were in the rules of the agency that was issuing the summons, instead of the court that was adjudicating summons. If I remember, that was the rationale.
That, like every rationale I've heard about this, just falls apart. I mean, the internet is a very powerful tool. Searching for things, we can make it easier, we should make it easier, but I still don't understand what this language really means that we're voting on. It's vague. And it, again, represents a continuing diminution of our responsibilities, and is inconsistent with a healthy separation of powers.
I mean, is it inconsistent also for us to, just on the flip side of that, to have power, if we vote not to change this for DEP, is it inconsistent for us to just have it here, the ability, as opposed to the other agencies? I mean, why?
I'm sorry, Lisa, I'm not following.
So if we retain the authority to set the penalties for water,
Mhm.
but we don't have authority for any other agency, is that inconsistent in our role as under, our role on this board? And the second part of that is, how, we're enforcing, so basically what was done previously was that these penalties were then put back to the agencies to set penalties, and then now we're enforcing those penalties, but we have no ability, we haven't made a determination whether those penalties were fair. So those penalties went back to those agencies rather, and they said, okay, this is what we're going to assess. And then we have to say, oh, that's fair or not fair, because we don't have any ability to change those penalties once they come to us. We either say yes or we say no. So by delegating these penalties, and not just, now with DEP, we're also, we are, what was said before, basically abdicating our role to say, well, is this fair or is this not fair? Which goes back to what Matt said about, well, maybe we should really be looking holistically at the all of the penalties, if that's possible.
Well, and also, really, the only time any of us plays a policy role of any import is in connection with reviewing individual cases. And all we ever hear is our hands are tied. That's the penalty that's in the code. That's the refrain. Every time I get a panel package, I see a penalty that's obscene, and I don't even bring it up because I know my hands are tied. We've delegated this. We've abdicated all of our enforcement capabilities. And, this is what everybody dislikes about government. Grinding bureaucracy, and this is perpetuating it. We could renumber these rules in an afternoon and be done with it.
If the board set the penalty schedules and it set a penalty amount of $100 for a certain type of violation. If that case came up on panel, you wouldn't have the ability to change that $100.
I
in
would
that-
be
in
able
that
to
moment
go the next morning and say we should look at this penalty schedule.
and do additional rulemaking, because there's all.
I
of
have
this
no
goes through-
policy
all of this
authority
would
of
go
any
through
kind.
rulemaking.
I'm sorry, I didn't mean.
Yeah, I was saying all of this would go through rulemaking anyway. I mean, to your point, to Lisa, to your point, you're correct that it wouldn't be the boards that would have the authority to write the penalty schedules, but through the CAPA process, there's still opportunity to weigh in on the penalty itself. And
As a
Tom,
member
you were
of the
Tom and,
public.
right, yeah, Tom and then Madeline, I'm sorry.
No, I'm done.
Okay, Madeline?
Just to clarify, like, in terms of fine amounts, the city council sets the fine amounts for the most part. Sometimes there are ranges of amounts where the agency makes decisions. In other cases, they're stated in the law. There's no wiggle room when they're stated in the law. It doesn't matter what an agency does. Sanitation, in its penalty schedule, if it's stated in the law, we don't add it to our penalty schedule. They can go to the ad code to see the penalty amount, just as an FYI.
Where it's stated in the law.
Where it's stated
not
in the
stated
law, we have no jurisdiction over many of our penalties.
But I assume these are here because these are not stated in the law,
I think that's correct. Yeah.
right? So
Yeah.
I think we're saying that these are all going to get increased, not just changing the numbering. That's essentially what's going to happen.
Well, by delegating authority, then the DEP commissioner, in their discretion would determine through rulemaking, the changing of the.
Right,
Annotation,
so what
and
we
then-
would do is we would do a rulemaking where we would re-promulgate this schedule in our rules with the corrected section numbers. And then going forward, unless, I guess, if the board revoked the delegation at some point, going forward, this penalty schedule would be in our rules, and when it needed to be amended, it would be done by DEP.
I'm sorry, does DEP currently have in hand a revised penalty schedule that they're prepared to promulgate? That's
Sorry?
This is getting 86, right? Everything from water penalty schedule.
Right,
to-
it's being, so in other words,
Right,
it would
like-
be repealed from oath's rules and re-promulgated in DEP's rules.
I understand that, but is it being repromulgated in its entirety without edits, or is it being repromulgated with significant revisions?
The only revisions would be to change the references from drought to water shortage, because the rules are no longer called the drought rules, and to change the section numbers to conform to the new section numbers. We are not proposing to change any
Okay,
penalties.
so you're saying that the necessity is predicated upon the terminology, water shortage, no longer drought, and administrative edits to the numbering of
To the section numbers.
Why does that require a diminution of this board's responsibility?
I just would say on that, from our standpoint, all we care about is that if the mayor declares a drought emergency, we can write tickets for these regulations, which right now we couldn't for a lot of them because the section numbers in the penalty schedule are wrong. We originally came to this thinking that this would be a rulemaking done by oath. And then after discussions, it was decided that this would be
So-
a delegation
again,
from oath to us.
So Russ, all we're talking
But
about.
we don't care whether you promulgate it or we promulgate it, as long as it gets promulgated.
Well, then what, I'm sorry, one quick thing. Then in fact, you have established my point, which is that this is ministerial. If you have no designs on changing the penalties, and you have,
We do not intend to
well, then,
change any of the
excuse me, you're
penalties.
cutting across. Then you have in fact endorsed my point that this is ministerial. It doesn't require a diminution of the board's authority.
Again, we don't care who promulgates it, as long as it gets.
Well, if you don't care, then why are we doing this? I mean, that's just,
Listen,
I guess just from a timing standpoint, from DEP's perspective, wouldn't it be, it seems like this is going to require one rulemaking to delegate and then a subsequent rulemaking to adopt the corrected penalty schedule in DEP's rules. wouldn't it be, from your perspective, wouldn't it be quicker, at least in this instance, if there's the kind of urgent need to fix the section numbers so that you can enforce, wouldn't it be quicker for the board to issue a proposed rulemaking to do that now rather than having like a two-step process requiring two separate CAPA? It just seems like this is going to extend out the time if we have to issue a proposed rulemaking to delegate, which then has to go through CAPA before DEP can even put out a proposed rule to adopt the corrected schedule, rather than us just putting out a proposed rule to adopt the corrected schedule now.
Right, so on the timing front, that's the very last line, which is section 2, which says effective date. And the way that the effective date will work is that the two processes work not back to back, but simultaneously in parallel. So that by the time this rule, if it is adopted, gets implemented, then immediately the DEP penalty schedule will go into effect, as they will do parallel rulemaking on the.
And the law department determined that that was legal.
Yes.
Even though they wouldn't actually have the delegated authority
Yes,
yet under a final rule.
yes. I want to come to Tom's point about if the changes are limited, then why do this? And it is because we may find ourselves in this seat again and again. And it comes back to what I started with, which I understand that there's not universal consensus on. And that is that if the framework that we have right now is one where the penalty schedules sit with the agencies and not with the board, except with minor exceptions, then this presents an opportunity because it is coming up, whether it's a significant or minor change. It is still a moment, it's still an opportunity to right-size the ship so that the penalty schedules are now more or all, with the limited exceptions of ones that really aren't being used, with the enforcement agencies. That's why this is being proposed. It's an opportunity to make that adjustment. Whether folks agree with that adjustment or not, we'll put to a vote. But it is separate from the content of the changes. It's the delegation so that the board, so that the department, DEP, has this authority going forward. Other comments or questions? Okay, I would like to request a motion to vote on the proposed rule. Okay, we have a motion, Jared, a second. Okay, second for Madeline.
Okay, are there any objections to the motion approving the proposed rule?
Can we do a roll call vote?
Yeah, let's do that.
Okay, sure. Commissioner Asmer
Yes, in favor.
DOB Ivy Chu. In favor. Joseph Gregory. Elizabeth Nauer.
I'll say that my consistent vote on all of these repeals has been no. I guess at this point in time, I don't really see the point in objecting to, the one last item. So I'll vote in favor just because I do feel like there's some value to consistency. But I'm just putting on record that in general, in terms of this movement, I am not in favor of it.
Okay. Your final vote is yes.
Yes.
Madeline LaGorry,
Yes.
Russell Cunis.
In favor.
Wait. Is Russ allowed to vote here?
Yes.
Yeah.
Commander Paul Rama,
In favor.
Matthew Schneider,
No.
Thomas Bettner,
Profound no.
Matthew Smith,
In favor.
Douglas Swan,
Not in favor.
No.
Not in favor.
Lisa Urban.
No.
Jared Whittington,
Yes.
we have 9 yeses.
And how many votes?
We have 4 noes.
Okay,
The motion is approved.
okay, the motion's approved. Thank you, everyone. I want to note for the record, just because a question was raised regarding DEP, that even if DEP hadn't voted, the motion would have carried, would have been 8-4 and 1 abstention. I also want to thank everyone for their party discussion on this. As I mentioned, that I had a chance to look at some of the older discussions, and there was a lot of passionate views that came up. And so I appreciate that people brought very articulate and relevant points to this discussion. We're not always going to agree on everything, and that's why we put these to a vote, and that's why we have open discussion. So thank you for the thoughtful and civil discourse. Yes, Tom.
Am I wrong? There's no ambiguity, or that there's ambiguity at the end of the sentence there? Are we gonna not address that, or I mean, the die is cast, so maybe I'm just pushing against a rope here, but I don't really know what this means. And rules and regulations promulgated by the board. What is, you've got language that to me is best soft. That's charitable. So the die is cast, as ye sow, so shall you reap. It's not good.
Other comments?
Does that mean we're sticking with it? I mean, that's
It was voted on as drafted.
good. All right, well, the lawyer who did this can live with it.
Other comments? Okay, could I please have a motion to move to executive session? Motion? Second? We have a second?
Are there any objections to the motion to go into executive session? Seeing none, hearing none, the motion is approved unanimously.
Thank you.
Please hold.
Okay, we've returned from executive session, and the last item for today is selecting a date for the next board meeting. Let me suggest 2 options. These would be in February 6th or February 13th. Any comments or problems with either of those dates?
I would prefer February 6th if possible.
Sorry, did someone?
Also the
else?
same, the
Okay.
6th.
Does anyone have any problems with February 6th? Okay, then we will set February 6th as our next meeting. And I'd like to ask for a motion and a second to adjourn today's meeting. I see a motion and a second.
Are there any objections to the motion to adjourn the meeting? Seeing none, hearing none, the motion is approved unanimously.
Okay, adjourning today's meeting. I hope you all have a good end of year and holiday season, and we will see